Good evening, everybody. Let's make sure I'm not muted. All right, I'm not muted. This is Steve Lionel, chair of the Cities of Nashua Zoning Board of Adjustment, and this is the February 9th, 2021 Zoning Board meeting. As chair of the Zoning Board, I find that due to the state of emergency declared by Governor Sununu because of the COVID-19 pandemic and in accordance with the Governor's Emergency Order number 12, pursuant to Executive Order 2020-4 and extended by Executive Order 2021-1, this public body is authorized to meet electronically. Please note that there is no physical location to observe and listen contemporaneously to this meeting, which was authorized to meet electronically pursuant to the Governor's Emergency Order. However, in accordance with the emergency order, we are video conferencing using the Zoom application for this electronic meeting. Public access to this meeting is also provided via Zoom, and a link to the meeting is contained in the meeting agenda available on the city's website. The meeting can be streamed through the city's website, nashuanh.gov/318/CTV on Nashua's community link. The public may also view this meeting on Comcast Channel 16. We previously gave notice to the public of the necessary information for accessing the meeting through public postings and, where applicable, notice to abutters. Instructions have also been provided on the City of Nashua's website at nashuanh.gov and publicly noticed at City Hall. If anyone has a problem accessing the meeting via phone or Channel 16, please call 603-821-2049 and they will help you connect. In the event that the public is unable to access the meeting via the methods mentioned above, the meeting will be adjourned and rescheduled. The chair is in control of the meeting. To the extent practicable and advisable, the board will follow the procedures as identified in its bylaws. The applicant will present the applicant's case, followed by questions by the board. We will allow for a rebuttal period as best as possible for persons wishing to speak in favor or with questions or opposition before the board deliberates and determines an outcome. Normally, the board utilizes a light timer, which will not be available. However, the board and all participants should endeavor to comply with the timeframes of 15 minutes maximum for the applicant and 5 minutes each for anyone wishing to speak in favor or in opposition or with questions. Applicants, their representatives, and individuals required to appear before the board are appearing remotely and are not required to be physically present. Applicants, their representatives, and individuals required to appear before the board may contact the planning department to arrange an alternative means of real-time participation if you are unable to use Zoom. Documentary exhibits and/or visual presentations were submitted in advance of the meeting so that they may be displayed for remote access viewing. Real-time public comment can be addressed using the Zoom virtual meeting software for remote access or by telephone. Real-time comments via audio will be addressed at the conclusion of the public hearing. The public is also encouraged to submit their comments for future meetings via email to the planning department email, planning@nashuanh.gov, or by mail. Please make sure to include your name, address, and comments. Letters should be addressed to the planning department, P.O. Box 2019, Nashua, New Hampshire 03061. Please note that all votes taken during this meeting shall be done by roll call vote. Zoning board meetings will be held electronically until it has been deemed safe to conduct more typical meetings at City Hall. The zoning board, the planning department, and the city staff thanks you for your understanding and patience during this difficult time. Tonight, we will be hearing requests for deviation from the zoning code in the form of applications for variances. A variance is a request that speaks permission to something that ordinance does not permit. Variances also have 5 points of law to be met that are in the application and will be discussed during the meeting. Per the City of Nashua bylaws and State of New Hampshire revised statutes, a minimum of 3 or more affirmative votes are required to approve any application. In addition, this board will hear all scheduled cases if a quorum of 3 voting board members are present at this meeting. Any citizen has the right to contest the decision that this board makes. Should we make a decision that you believe is in error, you have the right to request a rehearing. A written hearing request must be received by the City of Nashua Planning Department within 30 calendar days from the date of decision. Should this board not grant a rehearing request, you can file an appeal directly to the New Hampshire Superior Court. Please contact Mr. Falk of the Planning Department for more information. So for this meeting, we have the following full board members in attendance. Myself, Steve Lionel, is the chair. Jack Currier is the clerk. JP Boucher is a full board member. And let's see, Rob Shaw has not joined us, and Mary Ellen McKay, who is our vice chair, will not be here tonight. We also have, yes.
Steve, this is Rob Shaw.
Oh, hi, Rob. Oh, you are there. Okay, I'm sorry.
I joined right at 6:30.
Okay, sorry, I overlooked you. Okay, Rob Shaw is here. Very good. And we also have an alternate member, Evstasia Boris. Ms. Boris will be voting because we do not we have 4 of the 5 regular board members present. In addition to board members, we also have with us Mr. Carter Falk, Deputy Planning Manager, and Ms. Kay Poirier, Zoning Coordinator. Let's see, is Matt Sullivan here also? Yes, here he is. Okay, Mr. Matt Sullivan, Planning Department Director. We'll start the meeting by taking a roll call attendance. When each member states their presence, please also state whether there is anyone in the room with you during this meeting, which is required under the right to know law. Let's see, I will do that. Jack Currier.
Jack Currier is present. There's nobody in the room with me.
JP Boucher.
JP Boucher is present, and there's no one in the room with me.
Rob Shaw.
Rob Shaw is present, and there was no one in the room with me.
Okay, Evstasia Boris.
Evstasia Boris is present, and there's no one in the room with me.
And I am Steve Lionel, and there is nobody present in the room with me. So I said Ms. Boris is an alternate, and she will fully participate in the meeting and in the voting. Mr. Falk, do we have any changes to the agenda tonight?
Yes, Mr. Chair, we have one change. The First Church of Christ Scientist as the owner, Crimson Properties was the applicant at 115 Concord Street. They did request a use variance to move the church and construct a multifamily building. That case was advertised, but as soon as we advertised it, they withdrew it. So that will not be on tonight.
Okay, very good. So that was, yeah, that case will not be heard. Before we get started, Alderman Dowd has requested a few minutes to speak on our first case because he has to go to the aldermanic meeting. So Mr. Dowd, I turn the floor over to you.
Thank you very much. I appreciate being able to speak. We have an early meeting tonight at 6:45 with the Board of Aldermen, so juggling Zoom meetings. On this first case on 49 Buck Meadow Road, I have submitted a letter earlier with my thoughts on it. It's my understanding, I think, that the applicant is looking for proceeding under a grandfather clause. I don't see any thing that warrants a grandfathering clause for the intended use. And I think that these planning staff can talk to that more. Also, as far as the variance is concerned, you have to meet the 5 points of law. I don't think there's any hardship on this piece of property. It can meet any of the things that are allowed in an R40 zone. So I would recommend that that the grandfathering not be allowed and a variance for this lot for the intended use be denied. So thank you very much for allowing me to speak, and I have more detail in my letter, but I'm sure I have many pieces of correspondence on that one case. So thank you very much.
Okay, thank you. Okay, so I will now read the first case into the record. Owner is Ernest and Constance Gagnon. The applicant is JLS Holdings by its attorney, Tom Hildreth of McLean Middleton Law Firm. Address is 49 Buck Meadow Road. Sheet C, Lot 18, requesting use variance from Land Use Code Section 190-15, Table 15-1, Item 148, to allow a landscaping business and landscaping equipment storage. This is in the R40 zone, Ward 5. Is there somebody here to speak to this case?
Yes, Mr. Chairman, Tom Hildreth, counsel for Stanton Landscaping, and their related company that's the applicant here.
Okay, would you give your address, please, Mr. Hilders?
Sure. My office address is 900 Elm Street in Manchester, and I live at 15 Broad Street in Hollis.
Thank you.
Sure.
Proceed.
Thank you. Mr. Chairman, I first of all want to thank the board for the continuances that we've had since December 8. I hope we've used the time well. I don't know if all 5 members here were at that meeting. I hope that anyone who wasn't has had a chance to read the minutes. And I want to compliment your minute taker. I thought the minutes were outstanding in capturing what we covered. I don't want to go over that same ground again. We needed the time to do some additional factual investigation. We had the holidays intervening. I had COVID in January, as did David Christensen, who was the broker for the seller, who's been helping pull together factual information on the case. I appreciate the board's indulgence and as well as that of the other parties interested in the case. When we were here in December, we focused on 4 sources of information about the historical use of the property. We had an affidavit from the owner who'd been there for 75 years. We had letters from his 2 abutters who've been there for 25 plus years and 40 years on the other side. We had city records and we had aerial photographs that all spoke to the historical use of this property as both a home and non-residential uses, a contractor's yard, commercial businesses of various kinds. And when we left that meeting, there was a request by the board for more information from the applicant to expand on what we could find out about the uses and also to propose some conditions on use in terms of how the applicant envisions using the property going forward. So we've provided substantial additional information in the form of affidavits from the 4 parties named in Mr. Gagnon's affidavit, the landscaping companies who've been using the property continuously for the last 20 plus years. We've submitted kind of a compilation chart that shows the overlapping time that some of those users were on the property together. We've submitted a detailed list of proposed conditions. We've done an assessment of the character of the neighborhood and spoken to the issue of traffic. And I wonder whether I can be permitted to share my screen and just go through some of the highlights of those submissions. Is that something that staff can provide?
You're all set.
I'm all set. Share screen. Okay. Let's see.
Mr. Chair, before we proceed, this is John Cronin for Sean Tibbetts. Could I raise a point of order about procedure?
How about you do it in the chat window and we'll discuss it there and let Attorney Hildreth proceed.
Very well. Thank you, Mr. Chair.
If I'm doing this right, you're seeing the chart that's called excerpts from historic record. Is correct? I hope.
Yes, we see it.
Okay, great. Thank you. So we had referenced in our oral testimony last time substantial references from the city's own records on this property. And there was a request that we provide some of that additional information to the board. And we did that through this filing, excerpts from the historic record. So we included the 1988 minutes of the zoning board meeting when Mr. Gagnon had appeared for a variance to add a vehicle servicing repair shop operation. We also provided the 1998 building permit for the Quonset hut that was specifically approved and added for his construction business, concrete forms, the material he used in his excavation business. I also included this 1999 reference. This was a case where the property came to the city's attention on account of its logging operations and some concerns that they may be in the wetlands buffer. But you can see that I'm not going to go into the actual document itself, that the summary here shows us that at that time, the city observed the landscaping business, wood brought in from off-site, the composting of grass, pile of loam and so forth. I do want to then go to the two Google Earth photos that are shown here, one from 2001 and 2008. And I'm going to just do that here. If I scrolled up, I hope that you're now seeing with me this picture from 2001. This is an overview of the property. This is a 10-acre site. You can see it's kind of irregular geometric shape. And you can notice, can you see my cursor going across that screen as well?
Yes.
You can see the home. This is where the 5-bay garage is behind the home. This is a chicken coop that has since been removed. This is the Quonset hut. This is the driveway that's used to access this rear part of the property. And these are vehicles, equipment, stockpiles of material that were on the property at that time. This is 2001. I'm going to scroll forward to show a similar image from 2008. And I chose this date because this is the date that is closest in time to the 2009 investigation of the property that the city made, and that resulted in the letter of January 2010 that said, we've investigated your property, we understand what's going on there, and we find no land use violations. So this is in 2008. Again, you can see now the chicken coop has been removed. The Quonset hut is here. These are vehicles associated with the parties who were then, resident on the property. And, they've also got some equipment and storage back here as well. This is the picture of the state of affairs in 2008. I'm just going to scroll back to my chart here. So we had the two photos, 01 and 08. In 2009 and 10, and I include these records in detail in your excerpts. I'm not going to go into them, but I do want to point out that there were at least 5 city officials involved in that investigation. Nelson Ortega, Chris Sullivan, Kyle Metcalf, Lucy St. John, and Carter Falk were all involved over a series of weeks and exchanges and meetings and site visits that resulted in a letter to Mr. Gagnon that said, in effect, the manner in which you're using your property in January of 2010, including logging, cutting wood, and landscaping, is consistent with how you've utilized the property for decades, and there are no violations of the Nashua Land Use Code. Again, this is an excerpt from the city's records. And we talked about this a little bit last time, and I just provided the additional detail here. So I want to spring ahead to what we've submitted since then. We submitted affidavits from the 4 companies who've been using the property and are named in Mr. Gagnon's affidavit. And if I've done this correctly, we're looking at a chart now that is got blue bars horizontally across the page. This says compilation of data from affidavits. I'm not going to read the details of each affidavit. They're there in your packets. I hope you've taken the time to look at them. They all say what the company does, how it uses the property, what kind of equipment it has, how many employees, how many trucks, and when they were there. And I've charted them across this graph to show you. So Dion Landscaping is the first one there from 1998 through 2015. And if you read their affidavits, you'll see in some cases they provided a range of vehicles and a range for a number of employees. I chose the mean or the midpoint. So if someone said 12 to 15, 13 vehicles. Or, you have to extract the details. But here you can see, I said Dion, 13 employees, 11 vehicles. Santos came to the property around 2000 and was there through 2017, 4 employees and 8 vehicles. And likewise, Salmon Brook, and then Southern New Hampshire Tree and Landscaping. And you can see that at the bottom, I've aggregated the number of vehicles and the number of employees covering those periods of time. And all of them except for Southern New Hampshire Tree and Landscaping have now left the property. And at the end of the chart, I've got the proposed combination for Stanton to join the property. And you can see, I hope by this summary, I can avoid having to go through each of the affidavits, but they all utilize the property in the exact same way that Stanton would use the property. That is, as a means of storing equipment and materials, vehicles, no operations, no employees there during the day, no retail use, and so on and so forth. And you can read that in detail in each of their affidavits. They describe what they do, and they all use similar terms. We also submitted this document that we call proposed conditions of the use. And here, if you can recall back to the photographs we saw earlier, we've tried to draw, a blue line around that part of the property that historically has been used in support of this use. And you can see the irregular shape there. This being the Quonset hut. This is the driveway off of Buck Meadow Road. This is the area where the vehicles and materials are stored, both over here and back here. And if I'm not going to take the time to read the details. This is roughly 2 acres of the 10 acres of this site. And we include a series of affirmative conditions. We've proposed limiting the use to 30 registered vehicle. We have suggested hours of operation. We have things that won't happen on the site. We talk about screening and site security. So that's all kind of expanding on the statement that we included in our own materials previously submitted. So I want to just take a second here to kind of sum up where I think that left us. Okay. So the point I'm trying to make here, remember, is that no variance is required because of the continuous operation of this use of the property. And so here's my conclusion on this section of the presentation. There was a fair amount of documentation provided in December in the form of the aerial photos, the affidavit of the 75-year property owner, corroborating statements from his 2 largest, closest, longest tenured neighbors, and several documents from the city's own records. I start with the presumption that the city actors were diligent, competent, and acting in good faith when they heard Mr. Gagden's testimony to the ZBA in 1988 about the longstanding commercial use of his property and then took no action to shut it down. When they issued a building permit to Mr. Gagden in 1998 to construct his 2,500 square foot Quonset hut to employ in his commercial excavation business. When they wrote their letter on January 4th, 2010, after an active investigation with no less than 5 members of the city staff, that the use was consistent with past practice and not a violation of the city land use code. And when Carter drew a similar conclusion last summer in his letter to Jerry Prunier from July of 2020. Would it have been helpful if Mr. Metcalf had included a series of photos in the file in 2010? Certainly. Would it have been helpful if Carter had included some measures to provide guidance to future stakeholders on the line between continuation of use and expansion of use? Undoubtedly. But the evidence presented, evidence exists to support and flesh out both of those dimensions. Ernie Gagden told us he rented portions of my land and Quonset hut building to area landscaping companies continuously for decades. He provided examples of the type of equipment stored and estimated there could be over 25 pieces stored in the rear of the property at any one time. We know the part of the property was involved, what part of the property was involved, because he tells us, Quonset hut and the rear. Mr. Gagden's testimony is buttressed by every available historical aerial photo of the property, which shows the area surrounding the Quonset hut and running to the rear as being involved in the storage of equipment, vehicles, and material. And now that testimony is brought even more to life by the detailed affidavit of the 4 companies specifically named in Mr. Gagden's affidavit. It's now easy to put these pieces together to reconstruct exactly what city officials saw when they inspected the property in 2010. We have the sworn testimony of the owners of the landscaping companies who were occupying and using the property at that time. Mr. Metcalf was correct in 2010. Mr. Falk was correct in 2020. All of the available evidence supports their conclusions. Mr. Stanton seeks merely to continue the same use in the same place in the same manner. And we believe that the evidence supports a finding by the board that no variance is in fact required. Mr. Chairman, if I may, I want to kind of switch gears here and
You have 2 minutes, sir.
okay. So let me just go through the rest of what I wanted to show you in particular. We submitted a document dealing with traffic safety. I'm only going to include these photographs to show you if I've done this right. There are 2 pictures on your screen. Both of them are from the point where the driveway to 49 Buck Meadow Road meets the road. Looking right, the first photograph, there's a sight distance of more than 400 feet. Looking left toward Main Dunstable Road, the sight distance is nearly 900 feet. There is no blind corner affecting this property. And each of the affidavits submitted by the landscaping companies further testifies that none of their employees or vehicles have ever been involved in a motor vehicle accident on Buck Meadow Road. And their combined years of operation approaches half a century when you add them all together. I assume, Mr. Chairman, that at some point you'll want me to address the staff memo, but I can wait and do that after the staff has presented that if you'd prefer.
Okay, are you done now? You have less than a minute left.
Yeah, because I have less than a minute left, there's not a lot of ground I can cover. So if I have a new chunk of time to address what Carter wrote in his memo, I'm happy to save it and do it then.
Okay. Thank you, Attorney Hildreth. Questions from the board? Anybody with questions? Mr. Courier?
Hopefully you can hear me.
Yes, we can.
The question I have for Attorney Hildreth is, I was using an average of employees, kind of like you had done as well. Although this afternoon we got, the additional, a couple of additional affidavits, but using the average for the 3 affidavits that were in our package, I come up with 22 employees. I think I think 28 or so, but we'll go with that, 22 or 28. And that was from a span of 2007 and 2013. So is it your testimony that if there's 28 employees, that to me would be approximately 28 cars pulling into the lot every morning and to go to work and get their assignments and drive off with the trucks? Is that the level of intensity that was going on from 2007 to 2013?
Mr. Courier, the one detail I don't know is whether every employee went to the site or whether they met at job sites, because they only needed one person to drive a vehicle to a site. So I can't tell you, but that would be the maximum, I would say. If every employee came to the site and left their personal vehicle and drove in a company vehicle to the various work sites, then that would be the maximum.
Yeah, I mean, I think I would calculate that as the average. The maximum, if we took the maximum, I was up at 33, but that was without the other 2 affidavits today. So, I mean, I don't think too many people carpool, and I don't feel that like a lot of people would be walking to work on Buck Meadow Road. So my feeling is that while those affidavits describe a level of intensity that's like enormous, quite frankly, I just don't feel that might have been anywhere near the level of intensity of the use, but feel free to correct me if I'm wrong. I'm just trying to understand, and I say that in a spirit. I live near there, I drive through there. I never saw that kind of intensity, but I was just trying to understand what intensity was really occurring there, because in the last presentation, it was really like a low intensity, yet these affidavits show an enormous intensity.
I guess, Mr. Courier, I would say I don't know what time of day you're out in the neighborhood mostly, and I can only really speak from the Stanton landscaping perspective. Their employees typically get to their storage yard at 6:30, and by 7 o'clock, they're gone. And so if you're not there during that window, you're not going to see the activity. You're just going to see the quiet lot where the cars are parked. And I'm imagining that the other landscapers have a similar pattern, but I don't have that level of detail from their statements.
Okay. And the other question I had is, you mentioned about, I guess I call it limitations that Santos is offering, and I didn't see that in the current package. And while you were speaking, I pulled out the package from December, and I didn't see it there. So is that something that was provided, and maybe I just missed it?
Should be in the package. Mr. Courier. I don't know if Matt or Carter can direct our attention to it. I had the 2 pages briefly on the screen, just focusing on the map, but there's a series of narrative statements there as well that, describe the fact that, there'll be no retail operations, no signage, no processing of materials and things like that. Matt or Carter, do you have a reference you can provide Mr. Courier so he can get his own copy of that?
I'm happy to, Carter, if you don't have it in front of you. So
I have it in front of me, but I've got about 500 sheets of paper in front of me. So
Jack, it's about 20 pages in. It's on the back side of a page, and it looks like this. It's called Proposed Conditions on Operations. It's got a picture of the use area in the middle of the page.
All right, thanks. That's helpful. I'm all set for now. Thanks.
Okay. Is there any other member of the board with questions for Attorney Hildreth? Mr. Shaw.
Yeah, I wanted to check up on a couple things. One is at least on the I think it's the bar chart, that blue one that was sent out, we got today. It does also show, I don't know if this is just from a sense of going forward what the applicant, is intending or hoping, but it shows for 2021, the Stanton enterprise included in those numbers. Is that just to basically show how that would work with Stanton operating there along with Southern New Hampshire Tree?
Yes, exactly, Mr. Shaw. Yep.
Okay. And then the other thing I kind of wanted to get at is, so, those numbers kind of pretty much indicate, 21 vehicles for those 2 operations, but your conditions note a maximum of 30 registered vehicles. I think you alluded to perhaps that number being what was kind of around the peak usage in the 2008 to 2014, 2015 timeframe. Is that the basis for that number? Because it seems a little high versus what's the kind of proposed usage with the
Mr. Shaw. No, it's a perfectly good question. The only other number that I had in the record before collecting these affidavits was the statement from Mr. Gagnon, who said that there were 25 or more, I think is the words he used. And, I tried to figure out, I've done some counting of aerial photographs where I could, get enough detail to count vehicles. And I've added these numbers up here, based on these affidavits that we've collected. And you can see that there's a 4 or 5 year stretch when there's 39, nearly 40 vehicles there, across all the users. And so Stanton is not looking to restore the site to that level of utilization. He really just wants it for his own purposes and to keep Southern New Hampshire Tree and Landscaping there as long as they want to stay. So I proposed 30 because it would be a number that would more than cover that. Quite frankly, in conversations with staff, I said, there's willingness to bargain on that. And if the board wanted to say, make that 25, I bet that's a number we could live with. But that's where I was coming at this from.
Okay, thank you. And then the just another thing I wanted to double check, and I think this was spoken to back in December as well, but you note the hours of operation being 6:30 a.m. to 6:30 p.m. Monday through Saturday. I guess the one concern I just again want to explore is that that would basically preclude any sort of like snow removal plowing operation to be done by whether it's Stanton or any other entity if this was to be approved going forward. So that is I guess understood and kind of implicit in this request. Is that correct?
Well, certainly not. I mean, they don't want to be precluded from snow plowing. So if there's a plow event that requires them to get, their vehicles out on the roads, outside of those hours, they'd want to be able to do that.
So I guess let me explore that a little bit because I thought that maybe Stanton did snow removal. Is that part of their normal operation already?
Yes, he does. He's out tonight, as a matter of fact.
Okay, so I guess I have some concern about
Although he's saying this, Mr. Shaw, I'm reading a text message that when there's a snow predicted, his drivers take their trucks home and have them off the property where they live. So they're already with them, and they'll plow and they'll return the vehicles to the property, the next day. So that it would
Okay.
not involve bringing people to the site, in the middle of a snowstorm to collect the stuff if they planned well.
Okay, so that means basically they can operate and do that function without basically accessing the site.
Well, they'd have their vehicles with them, right, in suspension.
Right. Okay. I think that's all I had at the moment, Mr. Chairman. Thank you.
Okay. Are there other board members? Okay, I have a couple of questions. Attorney Hildreth, you had made a reference to somebody coming before the zoning board in 1988. I haven't been able to find the record of what that is. My understanding is that, if they came before the zoning board, they would have been seeking a variance, but no variance has been requested or granted in the past, is my understanding. Could you speak to that, please?
Sure. The minutes of that meeting are in your packet, and this was an application by Mr. Gagnon at that time to add a use where they would be permitted to bring vehicles in off-site, customers, and do repairs of them. They have had a long-standing practice of repairing their own vehicles, their farm equipment, their construction equipment, their personal vehicles and so forth. They've got a lot of garage space to do that. And in 1988, they came before the board and said, I've got a son who's interested in, taking this from a hobby and turning it into a business. And, we would bring, people could drive their cars here and get them serviced. And so that was a kind of a change in the nature of what they were doing. Whereas they previously limited it to themselves, they wanted to be able to do it to others. And that application was denied. And the purpose that I brought that up, number one, it's in the record. It's a place where the property intersected with the town. But number two, it's got Mr. Gagnon's testimony in 1988 telling the board at that time, I've owned this property since 1946 and I've used it in all these different ways, including for his commercial construction, foundation, land clearing operations.
I see. So Mr. Gagnon at the time, that was his residence, and he had applied for a use variance to do some vehicle repair there, but at no time was there a request for operating a landscaping business out of this property. Is that correct?
That's correct.
I see. Okay. During the testimony, everybody received a message from Mr. John Cronin asking about whether the previous public hearing had been closed and objecting to introduction of late materials this morning that opponents were unable to verify. I had replied in the text to everybody that I thought that the meeting had not been closed, but then I'm corrected and was told that the public hearing was closed on the December 8th meeting.
There's also a line in that minutes that said that the meeting would be opened for the purpose of the applicant and staff addressing the issues that the board had asked to be addressed at the conclusion of that meeting.
Right. Okay. So thank you for that correction. So I don't have any further questions at this time. Any board member, last chance for asking questions of the applicant? Okay. So is there anybody here to speak in favor of the applicant? Do we see anybody?
Mr. Chair, I see none.
Okay. Seeing none, is there anybody with questions, concern, or opposition to the application who would like to speak?
Yes, Mr. Chairman, John Cronin, if I may.
Okay, Mr. Cronin, you have 5 minutes. Please give your name and your address for the record.
My name is John Cronin. I'm with the firm of Cronin, Bisson, and Zielinski. That's at 722 Chestnut Street in Manchester, New Hampshire. And I'm appearing this evening on behalf of Sean Tibbetts, the owner of 3 recent properties to this particular parcel, who has a butter status. That would be 55 and 54 Buck Meadow and 86 Ridge. And in light of the time constraints, I'll just remind everyone, I think at some time in school or sometime in our life, we heard the saying that you can put lipstick on a pig, but it's still a pig. In this case here, we have some very expensive lipstick, but it doesn't change the relevant facts. And when you look at what was submitted, and I don't know what, if any, weight you're going to put on that because of the record, but I'll just comment on it. If anyone here hopes that this case be denied, it should be Mr. Christensen. An occasion to review his affidavit, a document titled an affidavit. It is not an affidavit because a lot of it he has no personal knowledge about. Why he would title it an affidavit is beyond any idea that I have. And although we don't have the opportunity to cross-examine here, if we did, I would be very curious as to who. Very lengthy, very thorough, but it really doesn't contain any relevant facts. Neither did the other affidavits. Basically, what they're saying is there's a gentleman that owned a house and he used his land for a lot of different things, like many people in New Hampshire have. And at one point in time, he had a landscaper that had some materials there, but the house still remained a house for Mr. Gagnon to live in. There's never a full-scale identified commercial operation like Stanton, which I think I mentioned and read excerpts of their website talking about the breadth of their activities, their work with pesticides, and the status of their growing business where they're still seeking to hire people. This is a very different issue. And what kills the grandfathering, if you accept everything in those documents is true, to have grandfathering status, you have to have a legally permitted use that's continuous. By their own admission, the landscaping use went away in 2016. And when those uses came to be on the Gagnon property, the city had a zoning ordinance, they had planning regulations, and to my knowledge, none of those users obtained any permits to use that property. Now, we're not seeking for enforcement here, and I know it's hard to enforce these things and they happen all the time, but the starting point in any grandfathering analysis is what were the legally permitted uses that were ongoing or legally continuing permitted uses that existed before the adoption of the regulations. These uses, and they never got any permitting. So they have no status whatsoever. So I think the grandfathering issue, as detailed in, I'll use the rest of my time.
Mr. Cronin, you're sort of breaking up. We're having difficulty hearing you. We're still here, but maybe when you turn around.
I find it odd that a licensed real estate broker that has an economic stake in the transaction, as a bias, would render an opinion that there'd be no impact whatsoever to any of those values. I know he holds himself out to be with the Bean Group. I don't know the Bean Group is an excellent group. I can't believe his broker would support a letter of that type and kind with inclusion. I would hope to permit this for some reason that they had plenty of insurance, because I would expect them to stand personally and take responsibility for any damages that flow out of it. When you look at the criteria of the 5 elements for the variance, they don't meet one of them. As the selectman said, they don't meet the hardship. There's nothing special about this property that distinguishes it from anything else out there, and it certainly can be used consistent with the existing ordinance. I don't think you need anybody's opinion to determine that if you put a full-scale commercial business, whether or not those employees are going to be living in the house or you get an alternative use in the house, and they're accessing that blind driveway back and forth, that it's going to be a detriment to the entire residential character of that neighborhood. Maybe this argument is better for a zoning change, but under the current state of your zoning and the criteria for variances, they just don't meet it. And then you look at the balancing test. There's certainly other different locations within Nashua where Stanton Landscaping could locate. It may be convenient, may be affordable, may be the right price, but it's clearly not the right place.
30
And
seconds.
if you look at it, and this building goes in and is at full status with employees, no conditions to growth, they're a good company, sure they want to grow and do better, just not the right place for this particular property. We would ask that the not consider the grandfathering use and find that the applicant did not meet its burden of proof and satisfy any of the variance criteria. Thank you.
Thank you, Mr. Cronin. Is there anybody else? I see Mr. Dowd, Alderman Dowd, you would like to speak now with questions, concern, or opposition?
In opposition, and I decided to stay a few extra minutes. Just want to add some information that, and on that westerly looking picture on Buck Meadow Road, at 36 Buck Meadow Road, starting in the spring, we'll be building an access road to the new middle school, and there'll be construction vehicles going in and out of that access all day long until September of 23 when the middle school opens, and there will be 800 plus students in that school with parents and buses accessing the school via that property. So the traffic on that street is going to increase significantly, and the city would prefer not to have school buses and parents fighting commercial vehicles coming in and out of that lot. Thanks.
Thank you, Alderman Dowd. There anybody else with questions, concern, or opposition who wishes to speak? Not seeing anybody.
No, Mr. Chair.
Excuse me. Attorney Hildreth, you have 5 minutes to speak in rebuttal.
It's a little incredulous, and I can't understand the double standard, but I would just point out that the Tebbets family, including Mr. Cronin's client, own 5 properties on Buck Meadow Road, 3 of which are employed in the exact same way as 49 Buck Meadow Road, as storage yards for landscapers. In fact, as the record shows from the last meeting, Stanton Landscaping was located on one of those, 34 Buck Meadow Road, immediately adjacent to the new driveway to the school for the 5-year period ending last summer when they parted ways as unhappy landlord and tenant. And Mr. Cronin to call this a pig, then 3 of his properties that his family owns are the same pig. I don't think it's a pig. I think it's an appropriate use for these properties. It's a continuation of a use that's been going on there for decades. Mr. Cronin has repeatedly overstated size of Stanton operations. The minutes from December 18 show him saying there are 20 vehicles. That's never been stated. There are 4 or 5 trucks and trailers. And again, they were all located on a relative of his client's property at 34 Buck Meadow Road for 5 years. Apparently, when they're located on a Tebbets property, they're fine. They don't impact safety. They don't detract from property values. Only when they're across the street on the Gagnon property, they somehow have these pernicious effects. This looks like, to me, nothing more like, try to shut down the competition and drive the business to them. So I just shake my head at that. On the 5 points of law, those are summarized in our initial testimony. I would only add that I've introduced some additional information since then, including specific reference to the case of Belanger versus City of Nashua, which stands for the proposition that when a character of an area has a particular use, an applicant proposing to make a similar use is entitled to the relief required. And here, I think we've demonstrated in spades the character of this neighborhood, the character of our use, which is completely consistent with the character of each of the other landscapers who's used it. Somebody said that the landscaping operations ended in 2016? They did not. Southern New Hampshire Tree and Landscaping is the company that is still there. They're a landscaping company in addition to a tree service. So the use has continued. There's a concept in the law called municipal estoppel. The municipality made a decision in 2010 after a detailed investigation involving at least 5 staff members that what was going on in 2010 was permitted and had been going on for a long time. And it was not a violation of the land use code. And we've demonstrated exactly what was going on in 2010. Look at the chart, draw the line down. There were 39 vehicles and 25 employees from existing landscapers in 2010. That's what they saw. There were site visits. Nobody was hiding this. It was out in the open. When Mr. Metcalf said, we've made an investigation, your use is okay, that's a decision of the staff. That's an administrative decision. It was never appealed. That became the law of the case. And the board asked us last time, show us what was happening then, what's been happening since then, and prove that you are a continuation of that use. And I think we've done that, really done it to the best of our ability.
Okay, thank you, Tony Hildreth. Let's see. So, Mr. Cronin, you have, I think you are the only person left here in opposition. You may have a final rebuttal.
Yes, I mean, like I said, if you take everything as true, they don't meet the standard for grandfathered use. I could have a property that, I've used for a lot of different things over the years, and I could sneak someone in and use it. If I didn't go get approvals for that, it just counts. And whether the people were there before, Dion was the one that was referenced throughout as the landscaping operation. That's who submitted the affidavit. And they left, I think, in 16 or 17. It's the first time I'm hearing that this logger is now a landscaper. If it is, that landscaping business is very different than what's being proposed here. Thank you. I think you've got the gist of our points, and sent a chat there to send my apologies if anyone was offended by my analogies not intended. I think I said, and I'll say it again, very good business, growing business, and I think I said this was the wrong solution for it. Appreciate it.
Thank you. Okay, well, I will now close the public hearing.
If I could.
Who's speaking, please?
This is Sean Tebbets. I'm the owner of 54 Buck Meadow Road and 55 Buck Meadow Road.
I'm sorry, Mr. Tebbets, but you no longer have an opportunity to speak. I mean, we have a protocol we follow, and you had opportunity earlier. So my apologies, but our rules do not allow you to speak at this point.
Very good.
At this point, I will close the public hearing and open the public meeting for comments from the board. Mr. Courier.
Just unmuted myself. Well, I appreciate Mr. Hildreth and Mr. Sullivan pointing out those affirmative conditions. They were there in the package. I have them here in front of me. I had just missed that in my review. At this point, my struggle with this application is that the affirmative use conditions, are limitations there, but I feel that the use of the property, if it's say legalized through a variance as a business, could be substantially more than what it's seeing. As you know from my question, I was struggling with the affidavits because they show a tremendous amount of activity on the property, and it may have had a lot of activity, it may not, but I feel that if a variance were granted, it would allow substantially more activity, even with those affirmative conditions. I mean, maximum 30 vehicles in the time frame, but there could be a lot more cars coming and going. I do feel that it doesn't meet the test. It's not it's a big property, but it's perfectly fine for what it's zoned for. And I struggle with a variance being granted that I think would, I guess I don't find merit in the broker's conclusion that there's no negative impact. I think for the abutters along that way, if it is legalized as a business, there is a negative impact. And that's my feel for being a part and traveling through that neighborhood. So I don't think the application meets the points of law, and I'm open to hear 4 other opinions on this. That's where I stand at this time. Thank you.
Thank you. Mr. Shaw.
I agree with a lot of what Mr. Courier just spoke of. I guess the one thing that I've also struggled with, though, is kind of working through whether or not essentially there has been this grandfathered use and the continuity of usage that is being proposed. And some of what's been presented to us would seem to indicate that. And obviously, I appreciate the attorneys from both sides kind of, if you will, debating kind of that point, especially when it comes to landscaping operations. So, I mean, I don't think generally that the variance criteria can be met from a simple look at the property and the nature of the usage that could be pursued otherwise without the granting of the variance. So I still want to see what my fellow board members kind of think about this question of the continuity of use and whether or not there's a feeling that this is something that would be consistent with the previous use of the last, 20 some years, or if there has been that interruption. And then, the judgment almost seems to perhaps come down to what's been, the Southern New Hampshire tree and landscaping usage that has been continuous for the last 13 years or whatever. So I guess, like I said, I'd like to hear what the rest of you have to possibly say about that or arguments otherwise.
Thank you. Mr. Boucher.
Yes. Again, I want to thank both parties for their testimony. I also appreciate the amount of documentation we got. I went through this a couple of times. So my conclusion is, and after tonight, I'm more solidified in that conclusion that I believe that this is consistent with what's been going on there for many years. I believe that, we talk about character of the neighborhood, and again, I appreciate both applicants and both sides giving their rebuttal on that. But I truly believe that, paring it all down, taking away all the ancillary noise around this, I'm looking at this and I'm saying that yes, this was, to me, what's been going on there for many years. In some respects, from my conclusions, in my opinion, and also listening to what's been said, I also believe that it was probably, or could have been, again, according to, I have to take for base value, the affidavits from the people who actually were there. And, like Mr. Courier doing a little analysis, I think that maybe the site could have been more of an impact 10 years ago than it would be now, doing the same thing. So again, I think that this use or the uses that use there has been coexisting with that neighborhood for many years. I also believe, again, that that notwithstanding the issues here, like as far as like traffic goes and all that, you're going to add a school there. I think that's a great thing for the city of Nashua. I support that. But I don't believe that, let's just say 25 vehicles or I don't believe that is always an issue with anywhere we're going to be when there's vehicles. But again, I believe that this road is not what do you say? It's not restricted to any type of truck or tractor use, as far as I know. So again, anybody could be riding down this road in a truck and not going to the site. So I think that with the amount of traffic and what's going to happen in 2023, again, I don't see that as any deterrent to have an operation here. I do believe, though, that for myself, if this application had come to us where there was no existing use of that, or there was a use that had not been there for many years or had ceased to exist, I would find very difficult to support this application. But again, I'm going back to looking at what's actually been going on in the consistent use of this property for landscaping. I also believe too that when it comes to this particular property, again, I support this in general. Again, I'm not like going to put any restrictions on. I would just offer up that, again, if other board members, or if it felt that, hey, this is just a little too much impact, I would be in a position also to say, hey, if Stanton, I would say, hey, Stanton wants to operate out of here, and if it's just Stanton and just be his business and not any other business in there, but again, I'm not going there. I'm just, again, saying that I support this. If it was just Stanton wanting to go in here and continue with a landscape operation, regardless of any other leases or any other companies that are at this lot. And I understand that New Hampshire Tree Service is there, and I have no issues with that. Again, like Mr. Currier, I used to live on that side of Nashua, and that was when I used to bike. That used to be one of the routes I go, and I always recognized that there was things going on there. And I know from the past that there was a lot more going on this site than it is today. So again, that's my reasoning behind the fact that I don't think this is going to be as impactful. I also have full confidence that if it were to be approved here through us, with or without any stipulations, there would be a site plan obviously needed for this, and I think that would definitely solidify a lot of other issues or aspects of this site. So I'll leave it at that for now.
Thank you. Ms. Boras.
I actually concur with my colleague, everything that was stated.
Which colleague?
With actually Mr. Busher, with JP. I believe it is consistent use of the property, and I'm actually in support of it.
Thank you. Okay. Yeah. First of all, this notion of grandfathering, it doesn't really exist. I mean, if an owner, and let's say we've had cases where an owner had a barn that was exceeded some area variance and that had been there for 75 years and they were seeking to modify it, so they needed a variance, and we've generally allowed that sort of thing. But here we have something that a company wanting to operate, a new owner wanting to operate a business that is not permitted in that zone, and the previous owner was storing vehicles and owned a business that was not allowed in that zone. I have difficulty seeing how that meets the spirit and intent of the ordinance. I agree with Mr. Currier that there's no special condition of this property that makes it uniquely suitable for running a landscaping business. There's lots of these affidavits that don't really mean anything as far as I'm concerned, and some of them are just sort of opinions. And so no variance application has ever been made for running a landscaping business out of this property. It's never come before this board before. The case that was mentioned had nothing to do with running a landscaping business. This is a difficult case. There's lots of information, but I guess what I'm drawn to is I'm looking at the 5 points of law, and I just don't see that this application meets all of them. So I am not in support of this application. There are further comments from the board. Mr. Courier.
I did just want to mention, because Mr. Lionel, you had talked earlier about the previous case of 1988. I just wanted to affirm what Mr. Hildreth said. That was in our package. I know there was a lot there, but I had asked for that at the first meeting, and I appreciate staff for putting that in there. But I would summarize that case in a way. It was very analogous to tonight, because the board then in 1988 was struggling. It was recognizing that the land was used for more than just a home, and more than just kind of quiet farming, that there was other activities going on there, but the board struggled with legalizing that into a business, which could then, in my opinion, I thought the board struggled with what I am tonight, which is if it becomes a legalized business, the growth yet could be substantially more. And that's how I would summarize that case, but I just feel it's in a way so analogous tonight. And again, I continue to struggle with kind of memorializing it as a business for the further growth. So I just wanted to get out that I appreciate seeing that 1988 case and some of the similarities to what we're seeing tonight. So thank you for that opportunity to speak.
Any other board members wish to make further comments? No. Okay. What I'm seeing is 3 board members are not in favor and 2 board members are in favor. So I'm going to entertain a motion from somebody who we'll see what happens. Who would like to make the motion? I'm not seeing any hands. Mr. Courier, you're the goat. Okay.
I mean, I have a preference to be the note taker here as clerk versus making a motion. I would make a motion, but I would just throw that out first to see if somebody else would make a motion while I scribe it.
Well, I'll do it. And then I'll make the motion and we can discuss it. I'd like to make a motion on behalf of Ernest and Constance Gagnon, applicant JLS Holdings by its attorney, Tom Hildreth, address 49 Buck Meadow Road, requesting use variance from Land Use Code Section 190-15, Table 15-1, Section 148, to allow a landscaping business and landscaping equipment storage in the R40 zone. The board, I'm going to make this motion to deny the variance. The board believes that the variance is not needed to, may be needed to enable the applicant's proposed use of the property, but that there are no special conditions of the property, and the benefits sought by the applicant could be achieved by some other method, since the applicant is the land, the parcel is being sold for a new owner. So we believe there's some other method reasonably feasible for the applicant to pursue other than the variance. The board finds that this is not within the spirit and intent of the ordinance. The board has testimony, some testimony about property values of surrounding parcels, but we have no finding there. The board believes that it is contrary to public interest. substantial justice to the applicant would be served, but not enough points of the law are met, and therefore I make a motion to deny the use variance. Do I have a second? Mr. Shaw is a second. Okay, any discussion of the motion? Seeing none. Mr. Courier, how do you vote?
Sorry, just had to unmute myself. Mr. Courier votes in favor of the motion to deny.
Okay. Mr. Shaw,
Mr. Shaw votes in favor.
Mr. Boucher,
Mr. Boucher votes not in favor.
okay. Ms. Boras,
Ms. Boras votes not in favor.
okay. And myself, Mr. Lionel, I vote in favor. So that's 3-2. The motion is passed, but the variance is denied. Sorry, Attorney Hildreth, you have 30 days to request a rehearing. Please contact Mr. Falk if you wish to do that. We can't hear you, Mr. Hildreth. We still can't hear you. You're muted, and we couldn't hear you when you weren't muted.
Thank you for your time. I appreciate it.
Yeah, I think you need to turn your head to the right in order to get to the mic wherever your microphone is.
You hearing me now?
Yes.
Okay, I just want to thank you for your time. I appreciate it. I'm sorry for the result. Maybe we'll see you at the motion for rehearing.
Okay.
All right, have a good night.
Thank you.
Thank you.
Okay. Going on to case number 2. The owner is Oglesian Farm, LLC. Is there somebody?
Yes, I'm here. Debbie Gleason, for the record.
Okay, we're not
17 Greg
ready.
Road.
Not ready yet. I have to read the rest of the application, and then we'll start taking your testimony. The applicant is Deborah Gleason, address 10 Groton Road, requesting variance from Land Use Code Section 190-101, Table 101-7, to exceed maximum number of ground signs, 1 permitted, 2 requested, to install a 4 square foot sign on each side of proposed stone walls at driveway entrance. This is in the R40 zone, Ward 5. Now, Ms. Gleason, you are willing to, you have 15 minutes. Please give your name and address for the record. You're muted. Kate, maybe can you unmute her?
Can't unmute her, unfortunately. I can ask her to unmute.
She's trying to figure it out. If she's using the Zoom application,
Bottom left corner, Debbie.
the bottom left corner of the Zoom screen would be a
mute button.
Or float over your picture and look for the unmute.
I don't know what kind of application she's using. It might be a phone. Ah, there you go.
Yeah, no, it's weird because it was unmuted no matter how many times I tapped it. All right. Thank you, Mr. Chairman, and good evening, members of the board. For the record, my name is Deborah Gleason, and I reside at 17 Greg Road in Nashua. And I'm here on behalf of Second Nature Academy at 10 Groton Road in Nashua. What did I say? 17 Greg Road, 10 Groton Road. Too many G's. I'm here tonight to ask for a variance for a sign at the driveway of Second Nature Academy. Currently, we have a white post and rail fence with a white post outside the driveway with a 2-sided sign that drivers should be able to view from both sides of the road on Groton Road coming and going. The sign letters are very small. It's very hard for people to see what's on the sign and very hard for people to identify that there's a school on the property. If anybody's familiar with the property, it's located on a working farm, and from the road, you can't see the school buildings that are set back, and it's not discernible what type of business is there. So many people drive by thinking that it's a farm and they like to take the liberty of driving down and being curiosity seekers to find out what's down on the property. Also, I have found that people like to come to a complete stop on Groton Road to look and see if they can read the sign and find out what's going on. So the purpose is to have a sign that is easier to read from the road so that passers-by can identify the school, or new clients coming to find the school will be able to identify it from the road and find their way to the school. As I mentioned, there's an old post and rail fence there that we are removing, and we're putting up a stone wall in its place with posts on either side of the wall. And as you can see in these pictures, it'll be similar to the curved stone wall with the two posts, the second drawing. The one at the top is the type of lettering that we're looking at, cast metal lettering. We are not looking to exceed the size of the sign that's already allowable. What we are looking to do is break that size into two separate sets of letters, one on each side of the road, so drivers can see it no matter which way they're approaching the property, and make it a safer way for people to identify what is on the property. We feel that it's observing the spirit of the ordinance because it is going to make the property actually look nicer than it does now. It's going to be more pleasant to look at driving by. The houses in the neighborhood are very much spread apart. They're not close together. We wouldn't be interfering with anybody's view accessing their own property, and they really wouldn't even be able to see the sign because of the way the two walls are set up. There is currently a public park located across the street, and they have a sign right at the entrance of the park to identify the park so that people can see it. And really, we're just looking for the same thing that the public park has. We find that because we're a private school, we're not allowed the same type of signs that a public school is allowed. And so it's harder for us to be able to let people know that we're there. So we're looking to have the same type of signage that a school or a college would have, so that we can be identified as a school. We also believe that having the sign split in two is really not asking any more than a double-sided sign. It's just taking those two sides and spreading it on either side of the driveway versus one double-sided sign hanging from the post. With the new wall and the new stone pillars, there really would be no way to put a double-sided sign because there's no post there anymore. It would just be the stone wall. We've also noticed that other private schools in Nashua have received variances for more signage and larger signs than is allowable in their zone. So we're not asking any more than other private schools in the area are allowed to have. I thank you for considering our application for variance, and I don't think I have anything else to add.
Okay, thank you. Questions from the board? Anybody with questions? Not seeing any board member with questions. Last chance. Okay, is there anybody here who would like to speak in favor of the application? My
Mr.
cat.
Chair, I see none, other than the cat.
Other than the cat, yes. Anybody with questions, concern, or opposition to the application? Seeing none. Okay. So I will close the public hearing and open the public meeting. Mr. Shaw, your comments?
I'm in full support of this. It seems like a very straightforward application. I think the fact that the square footage is not increasing beyond what's normally allowed makes this very easy to support.
Thank you. Mr. Boucher.
I'll support the application for the same reason that Mr. Shaw stated.
Okay. Ms. Boras.
I'm also in support of the application as submitted and as my colleague stated.
Okay. Mr. Courier.
I'm also in support of the application. I'd also like to say that I think it's a tasteful way to have a sign that gets the job done. I feel it'll accomplish it. The traffic does move kind of fast there, and I think you're going to see it from both directions, and it's in keeping with the character of the neighborhood. So when I first just saw this application, I was kind of thinking what's up there. But when I got the application, I thought, wow, that to me, it's a nice job, and I'm in support of the variance for the 2 signs instead of 1.
Thank you. And I am also in support of the application for all of the reasons my colleagues have given. Is there somebody here who would like to make a motion? Mr. Shaw, please.
I'd like to make a motion on behalf of owner of Gleason Farm, LLC, Dennis Gleason, applicant Deborah Gleason at 10 Groton Road, requesting a variance from Land Use Code Section 190-101, Table 101-7 to exceed the maximum number of ground signs where 1 is permitted, 2 are requested to install a 4 square foot sign on each side of proposed stone walls at driveway entrance, and this is in the R40 zone. The variance is needed for the applicant's proposed use of the property, given the special conditions of property. Specifically, special conditions are with the nature of having the stone walls erected for this entrance, that it's not possible to actually do a 2-sided sign like one might normally do, and to actually have visibility of the sign for traffic approaching from either direction. Having a sign on both sides of the wall at the driveway entrance will allow that to be accomplished. The actual square footage proposed is less than what's allowed, and this will also serve to support potentially the safety benefits as far as helping direct people to the property properly. So it is within the spirit and intent of the ordinance. There's no indication of any negative effects on the parcels, the surrounding parcels for their property values. It's not contrary to public interest, and substantial justice will be served. So I therefore move to approve this area variance request.
Okay. All right. Mr. Boucher seconds. Thank you. Any discussion of the motion? Okay, then we will take a vote. Mr. Shaw, how do you vote?
Mr. Shaw votes in favor.
Mr. Boucher?
Mr. Boucher votes in favor.
Ms. Boras?
Ms. Boris votes in favor.
Mr. Courier?
Mr. Courier votes in favor.
And I'm Mr. Lionel. I also vote in favor, and that's unanimous, 5-0. Congratulations, your variance has been requested.
Thank you. Thank you very much.
Please note that there is a 30-day window of appeal that somebody could appeal our decision. And if you have any questions about that, please contact Mr. Falk at the Planning Department.
Great. Thank you so much. Have a great night.
Thank you. Moving on to case number 3. Owner Hartwell Brook Condos. Applicant is Public Service of New Hampshire, doing business as Eversource Energy. Address Hartwell Brook Drive. Generally between 553 and 559 South Main Street, Sheet A, Lot 323, requesting a special exception. I should have said at the beginning we were doing a special exception. I missed that. From Land Use Code Section 190-115, A1, for temporary work in an other wetland buffer to access transmission line pole for overhead wire replacement work. This is the RA Zone, Ward 7. Is there somebody here to present the case?
Yes, hello, I'm Tom Tatro. I'm a wetland scientist for Stantec Consulting. We're at 30 Park Drive in Thompson, Maine, and I'm a consultant for Eversource Energy. And their project is, I was trying to share my screen. I don't know if I need approval to do that, but so they're maintaining their line in Nashua and Hudson, the P134 line. It's an overhead transmission line. Oh, there we go. Perfect. And in order to access their corner structure, they're replacing their overhead line. It's called the optical ground wire. It's the highest most line on these transmission lines. And in order to get to this corner structure, number 65, they need to cross a wetland, which is defined as an other wetland with a 40-foot buffer by the town of Nashua. We recently got approval by the Conservation Commission. Access will be from South Main Street over kind of a residential lawn area, and then across an intermittent stream and a wetland, and temporary matting will be used to avoid any permanent impacts to those wetlands to gain access to the corner structure. And then it's really just a bucket truck going into that corner structure to unclip the old wire, install a pulley so the new wire can be pulled through, and then permanently clip in the new wire. And then everything will come out. The area will be restored. Any ground disturbance will be seeded and mulched and basically returned to the existing conditions. And that's it in a nutshell. If there's any questions, I'm happy to answer.
Thank you, Mr. Tetro. There are 9 special conditions for a wetlands special exception. Are you familiar with those?
I believe so. I think they were in the application, but I would appreciate a refresher if you want to go through.
The use cannot be reasonably avoided, and just tell us whether you agree to these. So that's the first one. That you have chosen the least damaging, best practicable alternative proposed. That acceptable mitigation is incorporated to minimize loss. That it's necessary for productive use of adjoining buildable land. That there are no rare or endangered species that will be affected. That there is adequate erosion and sedimentation control methods being used. That proposed activity shall not significantly impair wetland capacity for wildlife and fishery functions. That project shall not impair the stability of a water body's bank, and that wetland and buffer function of absorption capacity and storage shall not be impaired, excuse me. And you said the Conservation Commission had reviewed this?
Yes, we did a site visit with them. We had a meeting and then a site visit, and then they approved it a subsequent meeting after that.
So, so you agree that all of the special conditions are met?
I agree.
Okay, very good. Are there board members with questions for the applicant? Mr. Courier.
I guess maybe it's first a question for Mr. Falk, but was there like a summary letter? I think the minutes of the Concom said they approved it without any stipulation, but I just, do they not do letters, or did we not get it in the package, or did I miss that?
Mr. Courier, I never received a copy of their approval letter, but I do have the minutes. I think that was in your package that shows that they, as Mr. Tetro said, they did the site walk on November 4th, and they met on December 1st, and they recommended support for it by Chairman Dutsey and seconded by Commissioner Gillespie, and there was a unanimous approval for it.
So I see that in our package, and I'm good with that. I just was just curious about the letter, but I'm good.
We never got the letter. It was around Christmas time, and for some reason we never received it.
Yep. Okay. Well, I'm good nonetheless. That was the only question I had.
Any other board members with questions? Seeing none. Anybody here to speak in favor of the application?
Mr. Chair, I am seeing a hand raised by a Deb Gumpert.
I'm using Deb Gumpert. So my name's Ed Martucci. I'm the president of the Condo Association for Hartwell Brook. I don't know if I'm saying it, I'm out of turn, but
no, if you're speaking in favor of the application, you are fine. Please give.
No, I'm not. I'm not speaking in favor. I just wanted to ask a question.
Well, we will get to you in a moment then.
Okay, got it.
Right at the moment, we're asking for people who are in favor of the application. Okay, seeing none. Anybody with questions, concerns, or opposition? Now it's your turn, sir.
Okay, thank you. It's the first time I'm on this, so.
That's okay.
I just want, they did the conservation report. Actually, I just found out about this.
One moment, please. Would you give your name and address for the record, please?
My name is Edward Martucci. I reside at 10 Hartwell Brook Drive in Nashua, New Hampshire, and I'm the president of the Condo Association of Hartwell Brook.
Thank you. Continue.
Yeah, I didn't see the report on the conservation or whatever. That's okay. I just found out about this today, and wanted to find out exactly about I knew sometime in November, December, there was something going on with Eversource. And but I know that line where they're talking about fixing, it's kind of close to one of the homes at the end of the cul-de-sac. I just wanted to make sure that, is there going to be any scaffolding or any construction in the area where the houses are to do this work? Or it's because you showed pictures, but that was like in the buffer zone. But that wire does go very close to one of the houses at the end of the cul-de-sac. I was just wondering if that's going to be, is it going to be safe and that sort of thing.
Okay, the applicant will get a chance to respond to your question.
Okay, that's it. Thank you.
Anybody else with questions, concern, or opposition?
Mr. Chair, it looks like a Mr. Adam Genetti has his hand raised.
Mr. Genetti, please give your name and address for the record.
My name is Adam Genetti. I'm 553 South Main Street in Nashua. So I own the property that will be used for accessing the lines. And my question is in concern to the stream there. It is an intermittent stream, as was mentioned. I believe the work was planned to start in the springtime, which is when that stream actually runs the most. The pictures that you saw were, end of the summer. There's not much activity there. So my concern is just along the length of time that, the stream will actually be blocked off, as any water that doesn't go down that stream will end up in my yard.
Thank you. Your question will get responded to.
Thank you.
Anybody else with questions, concern, or opposition? Seeing none? Okay, thank you. Mr. Tetro, you have 5 minutes to respond to the questions that have been raised.
Sure. So the wire concerns, I'll kind of defer to the Eversource representatives here that are also on the call. But just saying that, the work is immediately around the base of the pole. It's just literally a bucket truck raising someone up to clip and unclip the wire. Jenny or Roy, I don't know if you have anything to add to those concerns from the adjacent landowner.
I'll add to that, Tom. I mean, I won't really add, but I will say that, yes, we'll just be driving in a bucket truck. They'll be lifting a man up into the bucket to unclip the wire, like Tom said, install a roller so that we can roll the new wire on. And then once the new wire has been rolled, it will be clipped in so that's secured. And then we will drive the truck off and we will remove all the wetland matting. So there's no major construction going to be going on in that area.
Ms. Menendez, would you please give your name and address for the record?
You're welcome. I'm sorry. My name is Jenny Menendez. I'm the environmental specialist from Eversource, and my address would be 13 Legends Drive in Hooksett, New Hampshire.
Thank you. So, the question about stream being blocked off, my understanding is that there would be no blocking off of the stream. Is that correct?
Yeah, I can answer that. So the mats that they use, I don't know if you're familiar with timber matting, but they're basically a 4 by 16 foot rectangle of square sawn logs that are bolted together, and they use a combination of those to either mat across resources, or in this case of the stream, they'll actually completely span it, so it'll be more like a bridge right across the stream. It won't block it at all.
Okay. One of the two people who spoke with questions has an opportunity to make a final comment if they wish, or you can just be satisfied.
All set.
Mr. Genetti?
I'm satisfied with that. Thank you.
Okay, very good. So I'll close the public hearing and open the public meeting. Mr. Boucher, your comments.
In short, I support the application. The package was pretty thorough. And that's about it. There's really nothing else that I'm concerned about. The wetland scientists explained exactly what's going to happen there. So again, I have I know that it will be done as said and by testimony. So again, I support the application as is.
Okay, thank you. Ms. Boras.
I also support the application as submitted. Thank you.
Mr. Kirsch.
I'm in support. I'd just like to say, I think it was a very thorough and complete application. It speaks for itself, but the testimony tonight was all the better. I'm good with it.
Okay, Mr. Shaw.
I likewise am in support and concur with my colleagues.
Okay, and I am also in support of the application. Is there somebody who'd like to make a motion? Mr. Boucher. Thank you.
I'd like to make a motion to approve the special exception for Hartwell Brook Condos owner, PSNH, doing business as Eversource Energy, the applicant, Hartwell Brook Drive, generally between 553 and 559 South Main Street, Sheet A, Lot 323, requesting special exception from Land Use Code Section 190-15, Section A, Subsection 1, for temporary work in an other wetland buffer to access transmission line pole for overhead wire replacement work. It's in the RA zone, Ward 7. We find that it is listed in table of uses. We find it will not create undue traffic congestion or unduly impair pedestrian safety. We find it will not overload public water, drainage, or sewer or other municipal system. We find that the special regulations are fulfilled, the wetland special conditions that are being met per the testimony of the applicant. I'll also note that on December 1st, the CONCON gave this a favorable recommendation. We find that it will not impair the integrity or be out of character with the neighborhood or be detrimental to health, morals, or welfare of the residents. With that, I make a motion again to approve the special exception.
Okay. Do I have a second? Mr. Shaw, thank you. Okay. Mr. Boucher, how do you vote?
Mr. Boucher votes in favor.
Ms. Boras.
Ms. Boras votes in favor.
Mr. Courier. Mr. Courier.
Mr. Courier votes in favor.
Mr. Shaw.
Mr. Shaw votes in favor.
And myself, Mr. Lionel, I also vote in favor. It's 5-0. Congratulations. Your special exception has been granted. As usual, there's a 30-day window of appeal that somebody might have appeal. If you have any questions, please contact Mr. Falk at the Planning Department.
Thank you very much. Appreciate the time.
Go on to case number 4, excuse me. The owner, State of New Hampshire, applicant Timothy Sullivan. The address is 52 to 54 Baldwin Street, sheet 62, lots 228 and 229, requesting variance from Land Use Code Section 190-16, Table 16-3 for minimum land area, 12,445 square foot required, 8,518.2 square foot proposed after lot line relocation to construct a 2-family dwelling unit on lot 228. This is in the RB zone, Ward 4. Is there somebody here to present the case? I thought I saw.
Attorney Prunier, he's trying to unmute himself.
Oh, he is.
Did I get it?
Yeah, you got it.
You got it, Jerry.
Thank you. For the record, my name is Gerald Prunier. I'm an attorney with offices at 20 Trafalgar Square here in Nashua. We're here looking for a piece of property next to off of Baldwin Street in Nashua. The area is, if you are going across the new Baldwin Street towards Fairmont Street, they're at the bridge. The property, the 2 lots are located on the left-hand side. There is a walking area, a paved walk that the state of New Hampshire has on that side of the bridge. The zoning is RB and proposes is to put duplexes on each lot, 1 duplex on each lot. The duplexes are allowed in the zone with a land density of 12,444 square feet. The topography of both lots is a problem as it goes down deep in the back. It goes significantly down in that area. My client have two lots, one of which, lot 62 to 29, with a lot line adjustment, will be a legal conforming lot. The area that's in question is lot 62 to 28. which has the density problem with the acreage. In both instances, however, which is unique, there is no request for a variance for the setback requirements on either one of the lots. The northerly lot, 62-228, the one that's in question, abuts the state of New Hampshire and has, as indicated, 8,518.2 square feet. The lots meet all of the setback requirements as I've indicated. As to the lot density with lot 62-228, it abuts the state of New Hampshire land. Katie, if you can just push that up to New Hampshire land again, which is wide open in that particular area, and which is not to be built on. Again, the topography in that area is significant as well. So there is going to be a lot of open space on the northerly side of that particular lot. The city is in need of housing, and there's not much land left. This is an opportunity to get a housing unit for the city that is significant, three bedroom duplex units. They'll have their own garage, and they'll have a driveway where they can have the second car, if that's the case, put in there. There is an, as indicated, the plan shows that there is no setback requirements, that they meet all of those requirements. The density requirement is on the state side, so that we will have an opportunity to have some open space. We don't have much space left in Nashua. This is an opportunity to at least get one housing unit without disturbing any of the neighbors. As indicated, as shown, the duplex units are very attractive, and they should add to the neighborhood. The intent is to build up towards the front of Baldwin Street, not towards the back. The trees that are shown way in the back are intended to be left as much as possible. If you have any questions, I'd be glad to answer them.
Thank you, Attorney Prunier. Any questions from the board? Mr. Courier.
I was wondering what would be the result if there was no variance? Would my understanding be that development would just be with a single family home versus a duplex?
That's a possibility, yes.
Okay, and why the consideration? Was there a consideration to maintain the current zoning versus seek a variance?
There was, but the idea is to provide some decent housing in the city of Nashua when the opportunity arises. This is an opportunity in this particular instance because of being able to use the state property as staying open, so it would provide the density, the land density for that particular lot. The other lot is legal and conforming, but there's just land in Nashua is very much in demand.
Oh, okay. Thank you.
Any other board members with questions for the applicant? Not seeing any. I think Mr. Courier asked the question that I was going to ask, which was what's wrong with making that a single unit residence?
Mr. Chairman, there's nothing wrong with making it a single residence, but it's an opportunity to have another unit in the city of Nashua, and without without making the lot, the unit not having a lot of land around it. This lot has a lot of land around it. It's open. It's just not all part of that lot. And the fact that it meets all the abutting setbacks required for this type of duplex.
Okay. All right, thank you. Is there anybody here to speak in favor of the application?
No, Mr. Chair.
Okay, is there anybody here with questions, concerns, or opposition to the application? So we have BZHOM, whoever, please give your name and address for the record.
Yeah. Yeah, Sarah and Robert Zimmerman, 33 Fairmount Street. We're the abutter adjacent to the two parcels being discussed. Our concerns are during the Parkway alignment, those three parcels were approved for single family housing only. That was part of the agreement when that was split up. Also, if you look at the current proposal to put two duplexes, which would now be 4 driveways, if you measure the distances from our fence to the walkway, I'm not sure you have enough room to put 4 driveways. So putting 2 houses back there, we're fine with. There's more than adequate property to do 2 single families, but to put 2 duplexes there the way they've been designed, I'm not sure it's appropriate. One of them, that's fine. The second one, I don't see it, but that's our concerns. Thank you.
Okay, your questions will be answered when we get back to Attorney Prunier. Is there anybody else with questions, concern, or opposition to the application?
No, Mr. Chair.
Okay, Attorney Prunier, you have 5 minutes to respond to the questions and concerns.
Thank you, Mr. Chairman. In answer to the opposition, the one of the lots is legal and conforming and will have a duplex on it. The other lot is an opportunity because of the fact of the open space that the state of New Hampshire has on that particular area to put another unit on it. It is an opportunity for the benefit of the city. It should not interfere with the Robinson land. It's just what we're facing with in the city of Nashua. It's an opportunity.
Can you speak to the question about an agreement from the city when the Parkway was put in?
There's no agreement that we're aware of. The title has been done. There's nothing on record. I don't have any idea, but maybe Mr. Robinson could tell us what where that is. We don't want to do anything that's illegal.
Okay, Mr. Robinson, you have 5 minutes.
This is Mr. Zimmerman. I do not have documentation, but when the realignment project happened, the parcels were owned by the state, and at some time in the last 10 years or so, they were sold. I don't know who they were sold to. But when it was being divided and the decision for the Parkway realignment, we were told as abutters that that parcel was going to be approved for 3 single-family homes. And we were at that meeting, and I couldn't quote the date. My concern is actually safety in regards to that is a main thoroughfare to come off a main street on Baldwin Street. It used to be the little one single bridge. Now we call it the highway bridge, and it's the main in and out of traffic. So we're talking about adding, instead of 2 driveways, we're now talking about 4 driveways. I'm more concerned about safety, and I do not think there's a reasonable amount of land and area for those 2 parcels to be able to put those driveways in a way that would keep public safety, not a question, not a concern. Thank you.
Thank you. And Attorney Prunier, let's see, actually no, I guess we're done. Excuse me. Okay, I will
Mr. Chairman,
Yes.
I'm just going to follow up with that, with the question, please, if I could.
Yep.
Again, just about the driveways, just for clarification. I'm asking Attorney Prunia, because I was brought up again. Attorney Prunia, can you tell us by the picture that the rendering you have for the new homes, I see the two garages are next to each other. Is that going to exceed the 24 feet that's allowed per property for a driveway width?
I don't think so. No, it's not, Mr. Boucher, but if I may defer this, our engineer, Sam Ingram, I see is here. If we could ask him, maybe he could give you a better answer than I could, if I may, Mr. Chairman.
Okay, Mr. Ingram, if you can respond to the question, and please give your name and address for the record. But he may not. Oh, here he is.
My name's Sam Ingram. I work for Meridian Land Services, Amherst, New Hampshire.
The address, please.
It is 31 Old Nashua Road, Amherst, New Hampshire.
Thank you.
So,
question about the driveway?
Yeah, the question to the driveway regarding was it the width requirement? Is that what the
yes,
question?
It is a 24-foot total width maximum in the city of Nashua.
Yeah, so at this time, we haven't done any design work in terms of placement of driveways or houses. It's, the conceptual stages for the exhibit that we prepared. So any design work that we did or that we are going to do, we'll make sure that they meet the town requirements.
Okay, thank you.
Yep.
Okay.
Mr.
Yeah, go ahead.
So just to follow up, Mr. Prunia, Attorney Prunia. So I guess what I'm hearing is, and just if you could just verify that, again, whether or not it's duplexes or a single family home on each lot, the width driveway could be 24 feet. And again, my point is that I just want everybody to understand that no matter where we are, which street we're on, we can have 204 feet. We can have cars in that driveway. There's no ordinance on the number of cars. I think, maybe there is a huge number, but to be parked in a driveway, the driveway could be, 60 feet long, and whatever you could park in it side by side, right, would be allowable, right? So I guess my point is that 24 feet is allowed, and that's what you're proposing.
Yeah, we will not exceed the 24 feet.
Okay, thank you very much. I'm all set, Mr. Chair.
Thank you, Mr. Boucher. So now I will close the public hearing and open the public meeting. So are there any members? Let's see, we'll go through. I'm getting tired already. Oh, look at this. Okay. Ms. Boras, do you have any comments?
Ms. Boras has no comments other than I'm in support of the application as submitted.
Okay, Mr. Courier.
I struggle with the application. I certainly appreciate the applicants, responding to the needs of housing in Nashua, but I don't see that as a criteria that we should be considering for a variance. I don't think there's anything special on the lot, that prohibits or warrants a duplex on the 228 lot. I'm gonna make a guess that when the state has these up for sale, they know that given the size of it, they're only suitable for single family homes, but the applicant's proposing to move the lot line. So, so they get a legal two-family, you might say, on one lot, but not on the 228 lot, which is what they're here for. So I think I have that, understanding correct. While there is somewhat open land around it, there is, a public way right next to it. And I think that in a bit offsets, the rather large backyard on the back side of it. So I don't see meeting the criteria for a variance for the single lot. I think a single family home would service it just fine.
Thank you. Mr. Shaw.
Yeah, I find myself in a very similar position as Mr. Courier. I mean, I appreciate the desire and, even the idea of having the extra unit from just a housing perspective, but don't see the variance criteria being met, as I think a single family home is still, quite doable on that lot. And so I guess I just can't find support for the application.
Thank you. Mr. Boucher.
I'm kind of on the fence. I can see some reasoning for proving the variance. I can see, some special condition as we look at this lot again, with the open space next door from the state would be the last house on that stretch before you go over the bridge. So I guess I could see that. I appreciate the abutters concern about traffic, and I know that traffic is much quicker now going by there. But again, my point was just to make sure that we understood that, the driveways I wouldn't be concerned about, the driveways or the cars, because no matter if it's single or duplex, I think that whatever is there for driveway can be filled by those residents. So so right now I'm kind of on the fence.
Okay. Let's see. Did I get to Mr. Courier? I did. I've lost my
We're
track.
down to you, Mr. Lionel.
I'm down to me. Okay, I see what we did here. I'm sort of with Mr. Courier here. I don't see any special conditions of the property that makes it appropriate to ask for a variance for a duplex when a single family house would be perfectly reasonable there. Just because the applicant wants to build a duplex, that doesn't hold any water in terms of the board's decision. And I don't, it doesn't seem to be necessarily, I mean, it's not out of character. I mean, the zone allows a duplex, but what is so special about this lot that makes it require a duplex? So I'm really not in support of the application. Any further comments? Mr. Courier.
Well, I just wanted to throw out that the proposed square footage is about 68% of the minimum amount. And I mean, perhaps I feel differently if it was close to, the minimum amount, but at 68%, that's, roughly a third off. I mean, it's pretty far away from the goalpost, and that factors into my opinion also. I just wanted to get that out.
Okay. So what I'm seeing again is we have 2 members in favor and 3 members not in favor. Would somebody care to make a motion? Mr. Shaw.
Make a motion on behalf of the owner, state of New Hampshire, applicant Timothy Sullivan, address 52-54 Baldwin Street, for request is for variance from Land Use Code Section 190-16, Table 16-3 for minimum land area, 12,445 square feet required, 8,518.2 square feet are proposed after a lot line relocation to construct a 2-family dwelling unit on lot 228, and this is in the RB zone. The area variance is not needed to enable the applicant's proposed use of the property. There are no special conditions of the property that warrant support a two-family dwelling unit when a single-family dwelling unit can be done on this property. And so I think the applicant has reasonable and feasible use of the property. So it's not within the spirit and intent of the ordinance. There's no clear indication one way or the other regarding property values of surrounding parcels. It would be contrary to public interest, and substantial justice would not be served, and therefore I move that the area variance be denied.
Thank you. Do I have a second? Mr. Courier seconds. Any discussion of the motion? Seeing none. Mr. Boucher, how do you vote?
Mr. Boucher votes in favor.
Ms. Boras, how do you vote?
I'm not in favor.
Okay. Mr. Courier, how do you vote?
Mr. Courier votes in favor of the denial.
Mr. Shaw, how do you vote?
Mr. Shaw votes in favor.
And I am Mr. Lionel. I also vote in favor of the denial. Sorry, the variance request was not granted. As you know, you have 30 days to file an appeal for a rehearing. Talk to Mr. Falk and the planning department.
Thank you, Mr. Chairman, members of the board.
Okay. So now we go to case number 5. The owner is Rocky Hansen, address 52 West Glenwood Street, sheet 127, lot 97, requesting the following variances from Land Use Code section 190-16, table 16-3. First, to encroach up to 4 feet into the 25-foot required rear yard setback, and 2, to encroach 3.5 feet into the 10-foot required left yard setback. Both requests to construct an attached 14-foot by 18-foot one-story garage addition in back of the existing garage. This is in the RA zone, Ward 7. Is there somebody here to present the case?
Yes.
Thank you. Mr. Hansen, give your name and address for the record, please.
Rocky Hansen, 52 West Glenwood Street, Nashua. And I'm looking to extend my garage. We're looking at this plot plan here. I have not to scale this little area here where I would like to add to the depth of the existing garage. The position of the home in relation to lot lines did not allow me to have a 2-car garage side by side in 2010 when we made a renovation. So my excuse me, my really only option would be to go back into the backyard here. If we go back to the plot plan, you'll notice there's two lines to the left of the picture we're looking at here. One of them goes on a pie shape, which gives me my 10-foot setback if we were going with that line. But then there's another line about 6.5 feet. So there's kind of a discrepancy here on which line we're working with within the city. One of them allows me or has me within my legal setback on the side, and one doesn't. So I think that's where the 3.5 feet may be coming into play here. Also, my property, the existing dwelling is currently non-conforming. If that was going to be the back property line, the existing dwelling is within that 25-foot spot. So I'm non-conforming currently. I'm not looking to equal that depth with the garage. It's probably about half of that depth, I would say. And it is a 1-story extension, not a 2-story extension. With this, the proposed addition from 10 or from 6/8/2010, that's a 2-story addition. We're only going to go one level, essentially, 9 feet tall, let's say. I sent in a bunch of photographs of the existing. Thank you very much. Is that you, Katie, working that? Thank you. So here is a visual of the back area. So that white door is the back of the garage. that's where the extension would attach to. The picture below is from the easement on the side of my property that belongs to Hartwell Brook. It's a fenced-in yard back there, so you would see, you know, minimal amount of structure, let's say. And if we could scroll down to some of the other photos. So this one right here, picture from the back, again, inside the fenced-in backyard. That's where we're looking to be. If we can scroll down a little bit more, if there's any more pictures, no. So that's the front of my home. There's no impact to the front. You won't even see the structure. That is the other side of my house with the side yard. You won't see the structure from there. That's a picture of the back, kind of indicating how close the house is to the fence. These pictures, I apologize, did not come on as clear as I would like it, but I tried to shade in where the structure would go. And you can kind of see those lines right there. That's essentially the size of where it would be from the angle I took that photo. Yeah, some of these weren't as clear as I would like them to be, but I think
That
we
one-
may.
That one
we may
couldn't.
have- I'm sorry?
That one we couldn't get the printout very well.
Yeah, that's okay. I think the other ones indicated pretty well. This right here is just a pencil sketch, essentially, of where it's going in relation with some elevations. So I think hopefully that gives you a good vision of what I'm trying to do. Only looking for about 4 feet in the rear setback, which really doesn't have any impact on anybody. I don't think. No one's really even going to be able to see it. And then the left setback is, I think, kind of a gray area. It looks like I make it on one image or one line and not the other. But so I'm curious to hear your input or any questions. Thank you.
Okay. Any members of the board with questions for Mr. Hanson? Mr. Boucher.
It's more for Mr. Falk. Can you just tell me why the two lines? What is it? What was that all about? Do you know?
Well, that's a good question. We have it as the lot line that's Kate, if you can bring that back up again, that plot plan. We have it as the line that's parallel to the garage in the addition, not the one that's further away. They asked for the variance 10 years ago to encroach 3.5 feet into that side, that 10-foot side. And when we look on our drawings, that's what we see is, even if you look on there's an aerial photo in the package as well. Kate, if you can see like that dark, thick line that also runs parallel with the garage on the side. And there's the next drawing that shows the non-aerial. You can kind of see that line is parallel with the garage and not pointed over in that area and that further to that side. So we think that's the correct property dimensions. And, we believe that the applicant applied correctly for the variances to the rear and to the side yard.
Okay, so I guess just one other question, and it doesn't really make a difference to me one way or the other, but do you know where the other lot line comes from? Where does that come from? Who does that come from? Do you know?
I really don't know where that comes from. I mean, it's shown on that plan, but we don't have it assessed that way. I mean, our plan that we have is based on deed references, and that's what we show in our records. I don't know what the other lot line is, and that happens from time to time where we see a lot line. I mean, it shows from some recorded deed, but it may be, on the adjacent lot and not this lot. But we think the lot line is the one that's short, that's closer in.
Okay, thank you.
You're welcome.
Mr. Shaw, or Mr. Courier, you had a comment.
Yeah, or I guess a question for Mr. Hanson. And, when I took a look at the property, I noticed what he had mentioned, you mentioned, Mr. Hanson, during your presentation as an easement to the condominium association. I was curious, what is the purpose of that easement? I mean, I didn't see anything like power lines running, or, is that some sort of like fire entrance or something to Hartwell Brook? What's the purpose of their easement there?
I am not 100% sure. When that development was put in made into a condo association, let's say, they had that access, and I don't know if it was an access into the development and then it changed during when they were building it. I didn't get into it too much. I researched it enough to notice that I couldn't purchase it in order to do what I wanted to do. But it's currently grass, flat grass, and it's just an area my neighbor and I actually take care of. So I don't really know why it's there or what it's about, but I believe it's owned by them.
Okay, thank you. And the other question I had is, I was just curious if this Jeffrey Land survey, at least in my copy, the right side's cut off. When was that survey completed, and did that survey speak to, the pie-shaped slice of land as to whether you own that or not?
So yeah, the right side of mine is cut off also. I don't recall, I may have had it surveyed, well, the previous owner before I purchased it, when we did the renovation, I think had it surveyed in order to get the addition approved. So in his research and his paperwork, he came up, or someone had this indicated as the two different lines on the side. And I remember looking into as to which one was valid, because obviously the further one to the left is a benefit to me. But we never really got an answer from survey, or I think we got a similar answer from Mr. Falk regarding what that's about. I'm not really sure. Either way, the town made us go with their line, and that's how we moved on.
All right, well, thank you. I mean, it's really maybe a suggestion is that if you hadn't done so, to maybe you might want to reach out to Jeffrey Land Survey again, because I would think that they would also provide the comment of who owns that if you don't. Maybe you do, and
right.
It may not even cost you anything, since the survey was already done and you're just have a question on it. But I just throw it out as might be worth a phone call. That was all that were the only questions I had. I'm all set. Thanks.
Mr. Falk, you had a comment.
Mr. Courier, if you look at the non-aerial view, Kate, if you can bring that up. If you look at where Glen Hoe Street comes up. Yeah, the non-aerial one. Yeah, that one. Where Glen Hoe Street comes up, usually right-of-ways have like a rounded, radius at the end. This is like a squared off radius. That's not a common way that some streets end like that. It may have been a continuation of Glen Hoe Street going up towards like where the power lines were, where we had that previous case. It may have been something like that. I'm just guessing, because that looks like it's about on line with that Glen Hoe Street, possibly. It's just a guess. I'm not really sure, but yeah, we have the property shown on that map right there. That's all.
Thank you.
Yeah, I recently had a question about my own property, about where one of the property corners were, and I hired a surveyor to restake and find all the pins, and they did that. It seems to me, I don't know what I suppose it's actually more of a question for Mr. Falk. What would be the approach that a homeowner would want to make if there's a disagreement on where the lot line is? Doesn't the deed it looks like it's very simple. It's a certain distance from certain pins, but what I'm seeing here is that there are two deeds that have two different descriptions as to where that corner is.
Well, if they really want to investigate it, they can bring the deeds to the assessing department and have them work it out. Perhaps there's perhaps the drawing isn't drawn correctly on our GIS maps, which are all done through deed restrictions or through deed measurements and numbers. So that's what they'd have to do. I mean, and we've seen that happen. It doesn't happen very often, but every once in a while, someone will say that, you know, they believe they own more land or less land, or their lot goes further back. And if they can prove it to the city, then, you know, we can adjust their map drawing, you know, accordingly. It may be that they have to pay more taxes because they now own more land than they thought they did, or even less land and get a rebate. So it doesn't happen very often. I'm guessing that line maybe had something to do with an old right-of-way or something like that.
Okay, I would have expected that there would be some sort of marker at that corner of the lot, as is usual, but isn't always. Okay, that was sort of my question. Any other board members have any further questions of the applicant? Seeing none. Anybody here to speak in favor of the application? I'm not seeing any other members of the public here. So therefore, there are probably nobody to speak in with questions, concern, or opposition. Not seeing that either. So I will close the public hearing and open the public meeting. Mr. Courier, your comments.
I'm in support of the application. I'm not really hung up at all on the pie shape piece. I mean, it is applied for as if the applicant owns the lesser amount of land. A couple of things that gives my support for the application is first that there's no additional encroachment to the side yard being asked for here, and just a little bit to the backyard, but not more than the existing dwelling is already in the backyard. I do think there's some special conditions here. I mean, that the house is built way on the left, if we want to call it that, of the property. And, with the existing garage, you wouldn't want to add a garage to the right side. So it makes sense if you want to add, you want to stick with the same side. And another special condition is that easement to the condo association. There's a decent width of strip of land there to the left that at this point looks like it'll never be built upon. It's just kind of space that this Mr. Hanson says he maintains. So we haven't heard any negative testimony, but I think the left side encroachment really bears no impact of significance to an abutter. So I'm in support of it as proposed.
Thank you. Mr. Shaw.
I pretty much concur with Mr. Courier. I mean, I think the encroachment is going to maintain the same as the garage addition that's already there. The extent of the addition in the back will be less than the existing dwelling. I see no significant imposition of this on any of the neighboring properties, and also again with the way this house is situated on the lot, this is really the only appropriate place to put this kind of addition. So for all those reasons, I'm in support.
Okay, thank you. Mr. Boucher.
I support the application for the same reasons that Mr. Courier and Mr. Shaw stated.
Ms. Boras.
I'm also in support of the application, as my colleagues have stated.
Okay, and I'm Mr. Lionel, and I'm also in support of the application for all of those reasons. Is there somebody here who would like to make a motion? Mr. Shaw, thank you.
I'd like to make a motion on behalf of the owner, Rocky B. Hanson, at 52 West Glenwood Street, for the following variances from Land Use Code Section 190-16. Table 16-3, firstly, to encroach up to 4 feet into the 25-foot required rear yard setback, and secondly, to encroach 3.5 feet into the 10-foot required left side yard setback. Both requests are to construct an attached 14-foot by 18-foot one-story garage addition in back of an existing garage, and this is in the RA zone. The variance is needed for the applicant's proposed use of the property, given the special conditions of the property. Those are that the house is already highly situated to this left side of the property. The garage is on this leftmost side of the house, and in addition to the garage, this is about the only reasonable place to do that. There will be no additional side yard encroachment versus the existing garage, and the encroachment to the back will be less than the existing dwelling. Those are the reasons why this is necessary. So within the spirit and intent of the ordinance, there's no indication of any negative effects on surrounding property values of parcels, surrounding parcel property values. I always get hung up on that one. It's not contrary to public interest, and substantial justice will be served. And for those reasons, I move to approve this area variance.
I saw Ms. Boras's hand up first. She gets her name in the record there for a second. Okay. Any discussion on the motion? Seeing none. Mr. Courier, how do you vote?
Mr. Courier votes in favor of the vote to approve.
Mr. Shaw?
Mr. Shaw votes in favor.
Mr. Boucher?
Mr. Boucher votes in favor.
Ms. Boras? You're muted, Ms. Boras.
I'm sorry.
You're still muted. I can't tell what you're voting. You're still muted. Okay.
Ms. Boras votes in favor. Thank you.
Thank you. And Mr. Lionel votes in favor. So that's 5-0. Congratulations, Mr. Hanson. Your variance has been approved. Please be aware, as usual, there's a 30-day window of appeal. Should somebody wish to make a rehearing request, please contact Mr. Falk at the Planning Department if you have any questions.
Thank you very much for all your time this evening.
Yeah. Good night.
Thanks, Rocky. We'll be in touch.
Take care. Thank you.
Okay. We have no rehearing requests at this time. We do have an agenda for the February 24th meeting. Remind me why we're doing this on Wednesday. I forget.
Well, when we made the schedule back in October or November, we saw that February 22nd was a holiday that we thought we had off. So we had the HDC meeting on Monday and zoning board on Tuesday. So we had to make the HDC meeting on Tuesday and the zoning board on Wednesday. But come to find out, we do have work that day. So the HDC meeting and the ZBA meeting are just going to be switched to one night later, but it's just only this one time.
Okay.
That's the reason why.
As I looked at it, I said, I don't understand why, but okay, that's fine. But anyway, so it's the 24th.
You have the previous week, the previous Monday, but anyway, it's.
Yeah. Does anybody see any regional impact? I'm seeing no, everybody's head shaking, so we find there's no regional impact. We have two sets of minutes. The first set is from January 12th. Does anybody have any comments or edits to the January 12th minutes? Okay. So we vote on approving the minutes, yes. So Mr. Boucher, you want to make a motion to approve the minutes?
Yes, I make a motion to approve the January 12th, 2021 minutes.
Okay, do I have a second? Mr. Shaw is the second. Okay. Mr. Boucher, how do you vote?
Mr. Boucher votes in favor.
Mr. Shaw?
Shaw votes in favor.
Mr. Courier?
Mr. Courier votes in favor.
Ms. Boras?
Ms. Boras votes in favor.
And Mr. Lionel votes in favor. Okay, we have January 26th minutes. Mr. Boucher would like to make a motion?
I'd like to make a motion to approve the January 26th, 2021 meeting minutes.
Okay, do I have a second? Mr. Shaw, thank you. Mr. Shaw, how do you vote?
Shaw votes in favor.
Mr. Courier, how do you vote?
The Courier votes in favor.
Ms. Boras, how do you vote?
Ms. Boras votes in favor.
Mr. Boucher, how do you vote?
Mr. Boucher votes in favor.
And I, Mr. Lionel, votes in favor. Do I have a motion to adjourn?
So moved.
So moved and seconded by Mr. Courier. We're all in favor, I assume.
That was Mr. Shaw who made the motion.
Yes, Mr. Shaw made the motion. Mr. Courier seconded it.
8:55.
8:55. All right.